The United States is a common law country. This indicates that its legal system is based on the tradition of the customary law, which was developed in England and extended to other English-speaking countries, including the United States. On the other hand, we have the civil law system, which are based in written codes and laws that establish specific rules and procedures. For instance, we have Colombia. When an American citizen and a foreigner marries, conflicts of laws can arise. Therefore, we have to take into account first, law of the place of celebration, since it applies to determine the validity of the marriage. Second is the law of the domicile. It will determine the rights and obligation of the spouses, including child custody, property, and the division of the assets in a case of a divorce. And third is the law of the foreign spouse's country of origin. It may apply in certain cases, for example, in the assets of a succession or in the nationality of the children. Now we are asking which law takes precedence. It depends on the specific case and the applicable laws. However, the law of the place of celebration and the law of the domicile takes precedence over the law of the foreign spouse's country of origin. It is also important to say that the United States is a federal country. That's why individual states can also determine the rights and obligations of the spouse.
I am going to talk about applicable law in international divorces. In the case of an American and a foreigner, determine the applicable law in divorce involving a U.S. citizen and a foreigner is a complex matter that depends on multiple factors. The factors you may get to consider will be country where the marriage took place, country where the divorce action is filed, prenuptial agreements, the residence where both have been, and international conventions. The applicable laws will be the law of the country where the marriage was celebrated if the marriage was celebrated in the United States. The state law where the ceremony took place will be the starting point. Also, it could be where the law of the country where the lawsuit is filed, where they initiate the process of the divorce. It will be applying its own law. It could also be a law chosen by the parties. It could be if they previously agree on what law will govern this divorce. It could also be where the law of the country with which the marriage has a closer connection may apply. Consider factors such as the nationality of both and the places where they live together and have been established and the location of their assets. Example, if a Colombian citizen and an American citizen get married and want to get a divorce, they have to take in mind that it will be applied the law of the country where the lawsuit was filed. International conventions can be also a factor because both Colombia and the United States are party to various international treaties that may influence on the resolution of the case, such as the Hague Convention on the civil aspect of international child abduction, if they have a child. Also, it could be involve bilateral agreements on family matters that regulate issues such as recognition of marriage, divorces, and child custody. And also in this case, it could be a prenuptial agreements that specify the applicable law and other aspects of the divorce.
Let's imagine two Americans get a divorce in a foreign country and they want to validate that divorce in the USA in the state of Florida. Florida, as a state in the United States of America, is governed by the full faith and credit clause, Article 4 of the U.S. Constitution, which stipulates that judicial acts from other states and countries must be recognized as long as they do not infringe on the fundamental rights of the parties involved. For a foreign divorce to be recognized in Florida, two key requirements must be met. First, the jurisdiction. The divorce must have been issued by a competent court, meaning that the parties involved and a valid connection to the country where the divorce took place, residency, nationality, and other criteria. The second aspect is the due process. The parties must have been properly notified and given the opportunity to participate in the process. This is supported by the U.S. Supreme Court's jurisprudence in cases such as Williams versus North Carolina in 1945, where it was established that a valid divorce granted by a court from another state must be recognized, as long as there was jurisdiction and due process was followed. The case of Estin versus Estin in 1967 also reinforces this idea, emphasizing that foreign divorces are recognized unless they contravene the fundamental rights of the receiving state, according to the U.S. Constitution, Article 334. Now, in Florida, under Chapter 61 of the Florida Statutes, establishes jurisdiction over divorces when at least one party is a resident of the state. Although foreign divorces are not specifically regulated, the principle of domiciliary jurisdiction also applies in these cases. If the divorce was processed correctly in the foreign country, following its laws and without violation of rights, Florida will recognize that divorce.